Oyez, oyez. All persons having business before this honorable court are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Mr. McIntyre?
Yes, Your Honor.
I believe you're arguing first.
Yes, ma'am. May it please the Court. My name is John McIntyre, and along with my co-counsel, Ms. Tanner Hartnett, I represent Franklin Gas Company, the petitioner and appellant in this consolidated appeal. At this time, I'd like to reserve 2 minutes for rebuttal.
You may.
Your Honors, there are 2 issues in this case. I'll be discussing the first issue, explaining why, under the EPA's interpretation and the plain meaning of adjacent, it was improper to aggregate Franklin's natural gas production facilities. Ms. Hartnett will then discuss why the government has violated Franklin's due process rights by charging it with Migratory Bird Treaty Act takings. At stake in this case is holding the EPA within its administrative limitations so that the EPA cannot ignore its own regulation. Because the EPA has gone beyond the authority of Clean Air Act regulations, this Court should vacate the final aggregation determination and remand the proceedings. 3 reasons would support this Court's decision to vacate. First, the EPA has improperly minimized the regulation's adjacency requirement. Second, Franklin's sources do not make up the common sense notion of a plant and are not functionally interrelated. And third, under the plain meaning of adjacent, Franklin's sources are not within geographic proximity. I'd like to address the Court the law at issue in this case before I get.
You've mentioned the plain meaning of adjacent twice now. What is the plain meaning of adjacent in your view?
Your Honor, adjacent, as any dictionary defines the term, states that it means a source must be close by or near another source for it to be adjacent to one another.
How close do they have to be considered adjacent then?
It is a relative term, Your Honor, and the EPA does have some discretion to determine how much adjacency is required. However, the EPA must be bound to define adjacency within geographic proximity.
Do you really have discretion? I thought your argument was that under the D.C. Circuit's Alabama Power case, there was a clear statement rule. What is the relationship between a clear statement rule and deference or discretion?
Your Honor, under the clear statement rule, as the Alabama Power case described, that the EPA cannot go beyond a regulation's meaning when it prescribes the actual words within the statute.
Well, but I thought that the whole point of a clear statement rule is that there can't be ambiguity. If there's ambiguity, then the regulated entity doesn't know what to do. So I thought your argument was that the EPA had not issued a clear statement, and then sort of de facto there's no way there could be a violation, there could be a determination of a single source here. Or am I misunderstanding your argument?
In fact, Your Honor, my argument is that the EPA has acted arbitrarily and capriciously by going back and forth on what adjacency means. As the Supreme Court declared in the 2007 case of National Association of Home Builders versus Defenders of Wildlife, when an agency makes a final determination that is contrary to the facts and evidence, that agency has acted arbitrarily and capriciously. Because the EPA has acted arbitrarily and capriciously, under Section 706(2)A of the Administrative Procedures Act, this Court has the authority to vacate that determination. Adjacency does have a plain meaning under Section 71.2 of Title 40 of the Code of Federal Regulations, a regulation the EPA adopted and a word the EPA chose to use. The EPA has not chose to expand the meaning of this word beyond its own plain meaning, which it has the power to do so if it went under the proper comment and notice period under Section 533 of the Administrative Procedures Act.
So how close do facilities need to be to each other before they are adjacent?
The best precedent that we have, Judge Thacker, is that, as in a case from the Sixth Circuit from last year, Summit Petroleum Corporation versus the United States EPA. In that case, Summit Petroleum was also a natural gas operator, just like Franklin is, and the EPA aggregated sources together, saying that they made a single stationary source. However, the Summit Court shot down this expansive interpretation and applied the plain meaning of adjacency. and held that a well 500 feet away from a processing plant is not adjacent. As the record indicates on page 2 of this case, Franklin's closest source to its natural gas production facility is twice that distance away, 1,000 feet away. And by following the precedent laid by the Sixth Circuit, Franklin would urge this court to state that that is not adjacent.
Well, the Sixth Circuit is not precedent for this circuit, though, is it?
It is not, Your Honor.
Okay, I just wanted to be clear, because you mentioned twice that it's precedent, and we're not.
It's persuasive authority, Your Honor. Excuse me if I misspoke.
Also, just to be clear, are you conceding that the term adjacent or adjacency is ambiguous?
No, Your Honor, it is not ambiguous. While it is relative in a sense, the EPA is limited to defining the term or expanding on the term based on geographic proximity. But the EPA has defined the term based on function, and no plain meaning of adjacency defines the word as function.
Are there any cases that support the theory of functional likeness as being adjacent? Are there any cases at all?
Your Honor, there is one case out of the Ninth Circuit, McLaren's versus the United States EPA.
What's the facts of that case?
In that case, Your Honor, there were several natural gas wells, there were actually oil wells in that case, spread over an expansive area in which the operator connected them under a wheel and spoke model. And the EPA said that they were functionally interrelated and therefore adjacent. However, the issue in that case was not challenging functional interrelatedness, but it was actually a citizen suit in which the citizen challenged that the EPA did not aggregate the sources enough. However, under the 2000 case before the United States Supreme Court, Christensen versus Harris County, the court declared that when a term has a plain meaning, that there is no need for an agency interpretation. And that a court...
Are you then conceding that if we say it's ambiguous, then the Ninth Circuit controls when we go to functional interrelatedness?
No, Your Honor. The EPA has gone beyond its discretion by defining adjacency under functional interrelatedness. The EPA does have the discretion to lay down standards saying what adjacent may be. If the EPA wanted to lay down a standard that said X number of feet was adjacent, they would have the authority to do so. However, they have failed to do so here. And not only have they failed to do so, but they have gone back and forth on Franklin on what the meaning of adjacency applies. As the record indicates on page 3, Franklin initiated this procedure with the EPA and asked the EPA to not aggregate the sources together because under the guidance document at the time, the 2007 WIRM memorandum, the EPA relied on physical proximity. The EPA conceded on page 3 of the record that physical proximity was the primary factor in adjacency.
But would you concede that in law we can do strange things? We can create all kinds of fictions, and that we can very easily say that functional relatedness might very well constitute adjacent properties.
It may, Your Honor, but even under that interpretation, as my second point is, Franklin's sources do not meet the functional interrelatedness test. The EPA gets this test from a document known as the 1980 Preamble, a set of comments in Volume 45 of the Federal Register. And under the 1980 Preamble, it stressed that functional interrelatedness would be too subjective for the EPA to apply it. And however, the EPA has still continued to apply this for the last 2 decades. In 2010, a Title V order issued by the Colorado Department of Public Health and Environment defined functional interrelatedness as that 2 sources must be dependent on one another to meet this test.
I have a question. I don't understand why either the proximity test or the functional relatedness test make any sense when you're talking about air pollution, and you're talking about dispersal into the atmosphere. Why isn't there a test that actually looks at, for example, dispersion rates and determines whether something's a single source by how much is dispersed in a certain geographic area?
Your Honor, I cannot speak for why the EPA has chosen not to use a standard. However, under a physical proximity standard, it would address the EPA's concerns of air quality much better, because physical proximity is really what matters to maintain air quality. Functional interrelatedness is just a way for the EPA to go beyond its regulation and act arbitrarily and capriciously to aggregate sources together that really have no indication that they are harming the environment any worse than 2 sources that might be close by. under the plain meaning of adjacency, it would be much more rational for the EPA to aggregate sources that are extremely close together and that in the aggregate, as the pollutants float into the air, are more harm to the environment. What the EPA is trying to do here is overextend its authority and rein in power that the EPA does not have. Even under the functional interrelatedness test, since the sources are not functionally interrelated, the EPA cannot rein in its authority under Franklin's wells. Franklin's gas well can function perfectly fine without the gas processing plant. The gas well does not depend on the processing plant in any way whatsoever to pump natural gas out of the ground, and therefore severs this test. The EPA has also tried to rely on the common sense notion of a plant test to get around functional interrelatedness. But again, the 1980 preamble stresses that for this test to occur, that a support facility, which the EPA contends on page 3 of the record, would be the natural gas wells that supply gas to the plant. The support facility here must actually be a piece of processing equipment. And the wells do not make up a piece of processing equipment in the way that the 1980 preamble defines the term. A piece of processing equipment would be needed to remove hydrogen sulfide from the gas, and the well simply supplies the gas to the plant. Judge Rosenberg, you brought up the Alabama Power Company versus Coastal case a few minutes ago, and in that case, the D.C. Circuit in 1979 held that an operation cannot be a support facility. And an operation is exactly what a natural gas well is. It is completely separate and distinct from what the processing plant does. The EPA, as indicated on the record of page 4, has not laid out any of this criteria to make its final determination. And therefore, the EPA has acted arbitrarily and capriciously by making a conclusory statement without supporting any facts or evidence as to why the sources are actually adjacent under physical proximity.
What is the controlling standard of deference this Court should apply here to the EPA interpreting its own regulations?
Judge Thacker, under the Christensen case from the Supreme Court, if a word has a plain meaning without any need for agency interpretation, then the agency is afforded no deference here. Even in Auer versus Robbins, a case decided by the Supreme Court 3 years earlier in 1997, the Court declared that an agency cannot make a determination that is contrary to the law. The EPA's own regulation, Section 71.2, requires that sources be adjacent to one another. Without defining what adjacency further means, the EPA must be bound by the plain meaning of those terms. And by expanding that definition without going through the proper rulemaking procedure, the EPA has gone contrary to the law. And
if we believe that the term's ambiguous, though, we normally would owe Chevron deference to the agency's interpretation or deference to its own interpretation of its regulations, right?
Yes, Your Honor, you are correct. The Christensen case does point out that Chevron deference applies to agencies. However, it then goes back and states that when there is no need for agency interpretation, that the agency does not get that deference. And because the term is unambiguous, there is a plain meaning well established in the English language what this term means.
If we find it ambiguous, what's your best argument for why we should still say we don't defer to the EPA?
Your Honor, if you found the term ambiguous, you would be bound to follow the EPA's determination. However, under the EPA's determination, under the functional
we're not bound to defer to an EPA interpretation that's completely unreasonable or lacks rational connection to the thing being regulated, right?
Yes, Your Honor, you're correct.
So isn't your argument that the EPA's regulation is in all events unreasonable? It
is an unreasonable interpretation. You're correct, Your Honor.
And you're saying that because?
It's unreasonable because its definition of adjacency goes to function. If the EPA's definition of adjacency was limited to geographic proximity, that would be a reasonable definition of the term. However, the EPA has never defined that. In fact, as Summit indicates, the EPA for the last 2 decades has always applied this functional interrelatedness or common sense notion of a plant test and has never relied on physical proximity. By not relying on physical proximity, the EPA has been overreaching in its way that it has applied adjacency.
The regulation actually says contiguous or adjacent. What's the difference in your view, if any, in those two terms?
Your Honor, I see that I've ran out of time. May I answer your question and briefly conclude?
You may, if our
Yes,
Chief
you
Judge...
may.
Thank you. Your Honor, contiguous would mean touching, and as the record indicates on page 1 and 2, there are parcels of land that separate Franklin's gas facility from the gas wells, and therefore contiguous would not apply. Adjacency just means nearness and closeness, which would be the standard applicable here. And because the EPA has failed to apply that standard under proximity, they have acted arbitrarily and capriciously, and therefore this Court should vacate the final aggregation determination and remand the proceedings. Thank you.
Thank you.
May it please the Court. My name is Tanner Hartnett, and I will be addressing Franklin's second issue of why it did not commit a taking under the Migratory Bird Treaty Act or the MBTA. Your Honors, this is a case about the government punishing a corporation for violations of the MBTA despite that company's full compliance with suggested protective measures to prevent further migratory bird deaths. As a result, there are 3 reasons why this Court should reverse the findings of the District Court and render a judgment of acquittal for Franklin Gas. First, there was no takings because Franklin engaged in nothing more than passive activity. Second, the MBTA violates Franklin's due process rights by failing to provide adequate notice, and the government has not proved proximate cause. Finally, it is bad policy to punish operators for unintended effects of otherwise lawful commercial activity. Your Honors, a taking has not occurred because there was no intent to harm the migratory bird population.
Well, how do you balance that with the language that says indirect, by any time, by any means, in any manner?
Your Honor, that language in the MBTA modifies the words that follow it: take, pursue, hunt, capture, and kill. Now, while some of those words are clear in their meaning, words like take and kill have multiple interpretations.
But doesn't in any manner add a whole different light to it?
Your Honor, the phrase in any manner and by any means does expand the scope of those words take and kill, but only in terms of hunting and poaching. Any way that you can go after a migratory bird in that manner would constitute a take. However, looking at the principle of nociter suis, a canon of interpretation that states a word is known by the company that it keeps, this Court is bound to use the definition of take and kill that most closely relates to the words around it, in this instance, hunt, pursue, capture. All of those words add an element of intent. So while the MBTA itself is silent on a requirement of intent, the words that the government chose to include in the statute are enough to imply that element of intent, and take and kill have to be considered alongside.
Are there other areas of the law in which we criminally punish people or entities for unintentional killings?
No, Your Honor. The only other...
What about negligent homicide? What about drunk driving?
Yes,
Right?
Your Honor. Those are instances.
So why is this different?
This is different, Your Honor, because the MBTA itself is unclear on who it applies to and the extent of the harm required. In Colander v. Lawson, the Supreme Court in 1983 states that a criminal statute is required to be defined or so definite in a way that an ordinary person can understand its meaning. Here, the MBTA is not. It lacks specificity and instead uses broad, vague verbs typically associated with hunting and poaching rather than commercial activity. So it's unclear to corporations and individuals like...
Does that mean that the rule of lenity would support your argument?
Yes, Your Honor. When a statute, the rule of lenity states that when a statute is unclear so that an ordinary person cannot understand the terms, you have to defer and construe the statute in favor of the defendant.
Are there similar acts that define the word take?
Yes, Your Honor. The Endangered Species Act defines take in a similar manner, but it also expands it to include words such as harm or habitat destruction, which gives a much broader scope to the word take. However, that has not been accomplished by Congress at this time, and this Court is bound by the words that the government chose. And until the government goes back and takes the time to amend the MBTA or add a section specifically applying to commercial activity, then this Court is bound to look at the MBTA in its current form, which relates only to hunting and poaching. An example of
Well, the guidance that the EPA issued certainly gave you notice that this would apply to your commercial activity, not hunting.
Yes, Your Honor, and that goes to the second point today of whether the MBTA violates Franklin's due process. In United States v. Apollo, the 10th Circuit in 2010 laid out a two-pronged test to determine whether a due process violation occurs under the MBTA. There must first be adequate notice, and second, proof of proximate cause. Judge Thacker, the adequate notice in that case refers to adequate notice in the statute. So while the record at page 6 does indicate that the Fish and Wildlife Service submitted a letter to Franklin suggesting certain protective measures that the corporation could take to shield themselves from liability, that is not adequate notice in terms of due process, because due process addresses the notice within the statute. However, even if this Court wants to consider the Fish and Wildlife Service's letter as adequate notice, the government has still proven to show proximate cause, or has still failed to prove proximate cause.
Are you suggesting that industrial operations such as this should be free, totally free of any laws existing at this time to prohibit this type of activity?
No, Your Honor, that is not Franklin's contention. Franklin's contention is that we just need to know. Corporations like Franklin need to be able to read a statute and understand its applicability to them. Had Franklin known, they would have been able to adequately comply with the statutes. Now, going off of the fish...
You must have known something, or you wouldn't have. Why put the protective netting in at all? Why not just do nothing then, if the statute doesn't apply to you?
Your Honor, because the Fish and Wildlife Service reached out and stated that they felt corporations like Franklin would be held liable under the MBTA, Franklin played it safe and went ahead and covered their impoundment ponds. And they did so in good faith, thinking that suggestions by the government's own agency would be enough to shield it from liability. Nowhere in the Fish and Wildlife Service's letter does it state that covering the netting is not enough.
Along those lines, I've got some factual questions for you. In addition to the netting, Franklin was inspecting these ponds once a month. Is that correct?
Yes, Your Honor.
And then the EPA itself was inspecting the ponds once a quarter. Is that correct?
Yes, Your Honor.
Did the EPA ever give any indication that the measures taken by Franklin were inadequate?
No, Your Honor. Between the installation of the chicken wire and the bird remains that were found later in the year, Fish and Wildlife Service agents, as the record indicates on page 7, had been out to Franklin's property at least twice. And at no time does the record mention any complaints made by the Fish and Wildlife Service indicating either that the water level in the impoundment tank was too high or that the netting was too close or installed inadequately.
What else could Franklin have done to make it more safe?
Your Honor, the record indicates nothing else that Franklin could have done. The Fish and Wildlife Service's letter on page 6 specifically states to net, cover, screen, or otherwise render the impoundment ponds harmless to the birds. Franklin complied with that. Chicken wire covering an impoundment pond is a common practice in the oil and gas industry. And there was no reason that it should have been foreseeable to Franklin that it would have been inadequate, which goes to the proximate cause prong of the due process analysis. In looking at proximate cause, the courts consider foreseeability. In the United States versus Moon Lake, the District of Colorado in 1999 stated that when looking at foreseeability, you look at the propensity an action has to cause the harm. In this case, the harm being the death of the migratory birds. After the installation of the chicken wire, it was no longer foreseeable to Franklin or the Fish and Wildlife Service agents who viewed the property quarterly that there was any issue.
You're saying that excessive rainfall and a flood condition wasn't foreseeable?
Yes, Your Honor. In this instance, I am.
Do we know if there'd ever been that kind of rainfall or a flood previously in that area?
Yes, Your Honor. The record at page 1 indicates that Franklin is on the same shale play as Ohio, West Virginia, Pennsylvania, and New York. Looking at the Farmer's Almanac from 2009 to 2012 in that region, the data there shows that there was only one instance of heavy rainfall in the months of July and August. That was 3 inches in Ohio in 2011. However, looking at the day-to-day data, at no time in that region was there ever more than 2 days of consecutive rain, generally an inch or less.
What about before 2009? I mean, what about looking at the Farmer's Almanac, say, back to the beginning of the 2000s?
Your Honor, admittedly, Franklin has only looked back to 2009. However, the data has been pretty consistent over those 4 years, and as a corporation with outdoor operations, the most recent years would have been the years considered in evaluating their operations. And because it was not foreseeable that heavy rains would fall, it was unforeseeable to Franklin that the water would rise above the netting at that time of the year. Furthermore, in the region, according to the Farmer's Almanac, May is typically the heaviest season of raining. Now, the government points to possibly the flooding as what caused the sagging netting. However, if the flooding season is May, then there's no indication in the record that the sagging netting was found during that time period. So it's unforeseeable to Franklin, and with that unforeseeability, it's...
But what do you think caused this? I mean, I thought your position was the sagging netting was caused by the flood, right? I mean, that's what else. So why do you think the sagging netting occurred?
Yes, Your Honor. It's possible that the flooding did cause the sagging netting. However, because there was potentially heavy rainfall in May with the rainy season and no sagging of the netting occurred at that time, it was merely unforeseeable to Franklin that it would occur this time. Finally, Your Honors, it is bad policy to punish operators for unintended effects of otherwise lawful commercial activity. In that Moon Lake case, the District of Colorado points to the fact that courts should not interpret a statute in such a way that will lead to absurd results, which is exactly what will happen if liability is applied beyond the realm of hunting and poaching. The Fish and Wildlife Service's own information states that the automobile and trucking industry is responsible for over 60 million bird deaths.
But wouldn't your argument on this compel the conclusion that even if you didn't put up the netting, you wouldn't be liable? And is that what you're really saying? Are you really saying that if you'd done nothing, you still wouldn't be liable?
No, Your Honor. The absurd results does lend itself to that indication. However, Judge Rosenberg, the point of the absurd results is that looking at this and applying it only to the oil and gas industry is going to create discriminatory enforcement, which the Colander versus Lawson case, the Supreme Court addressed that issue in saying that a statute cannot encourage arbitrary or discriminatory enforcement.
But wouldn't failure to do anything tend to give a license for other folks that are in the same business or similar business to not paying attention to the wildlife kill laws?
No, Your Honor. It encourages the government to go back and amend the statute in a way that accomplishes the goals that the Fish and Wildlife Service have set out to do. As the MBTA stands in its current form, it's unclear, and it will lead to these absurd results. However, it's indication for the government to go back and take the necessary steps to clearly identify who is responsible and what conduct is responsible under the MBTA. Finally, Your Honors, this case is more analogous to the timber and logging industries that have typically been immune to the MBTA. The 8th and 9th Circuit have both held that the MBTA applies only to direct activity towards the migratory bird population rather than commercial activity, which merely causes incidental takes under the MBTA. And it's for these reasons that Franklin Gas Company asks this court to reverse the findings of the district court and render a judgment of acquittal for Franklin Gas Company. Thank you, Your Honors.
Ms. Ward? Go ahead.
Thank you, Chief Judge. Judges, may it please the Court, my name is Angela Worth, and I, along with my co-counsel, Andrew Missel, represent the United States government. I will show that EPA's decision to treat Franklin Natural Gas Company's production plant and wells as a single and major stationary source under Title V of the Clean Air Act was not arbitrary, capricious, an abuse of discretion, or otherwise in accordance with the law. My co-counsel will show that Franklin can be convicted for an indirect, unintentional killing of 5 migratory birds as a take under the Migratory Bird Treaty Act. Your Honors, this Court should not vacate EPA's decision for 3 reasons. First, EPA's decision was consistent with the dictionary definition of adjacent as well as common sense. Second, EPA's decision was consistent with the regulatory history of this regulation. And finally, EPA has offered a rational connection between the facts and the choice made. Your Honors, this Court should look at adjacent and see that it is an ambiguous word. And as an interpretation of its own ambiguous regulatory term, EPA...
Okay, but how do you deal in that case with Alabama Power, right? The D.C. Circuit said you need to have a clear statement. If it's ambiguous, it's not clear. And doesn't that trump any Chevron deference rationale?
No, Your Honor, because the Alabama Coastal case that you're referencing did hold that EPA needed to give oil and gas industry notice by creating regulatory criteria under which to determine whether facilities encompass the common sense notion of a plant. And EPA has done that. EPA has created 3 regulatory...
But they couldn't even answer the question multiple times when they were provided, that task. Doesn't that sort of definitionally show that it's not clear?
No, Your Honor. Actually, that shows how technical this question really is. It's a very technical issue. EPA has to apply the definition of adjacent across a number of different industries, and each plant is set up in a very different way. That actually shows that this is the exact kind of thing that our deference is premised on. Our deference, Your Honors, is premised on relative institutional expertise. And here, EPA is the expert agency tasked with understanding the Clean Air Act and determining whether sources are adjacent under the Clean Air Act. Your Honors, pursuant to Auer versus Robbins, an agency's interpretation of its own ambiguous regulation is controlling unless that definition is plainly erroneous or inconsistent with the regulation. Your Honors, looking to the dictionary definitions of adjacent, Black's Law Dictionary defines adjacent as lying near, but not necessarily touching. Merriam-Webster's dictionary defines adjacent as not distant, nearby, or sharing a common endpoint or border. An American Heritage Dictionary defines adjacent as close, adjoining, nearby, or contiguous. None of these definitions foreclose the possibility of functional interrelatedness being...
How do you account for the Supreme Court's Rapinos decision, right? I mean, wasn't that a case under the Clean Water Act where the Supreme Court said, the wetlands are 10 miles from the waterway, and even though the same water from the waterway gets into the wetlands, it's not close enough? Why doesn't that foreclose your argument?
Well, Your Honor, as you correctly pointed out, the Rapinos case involved the Clean Water Act, not the Clean Air Act.
But the Clean Air Act is based on the Clean Water Act, right?
Yes, Your Honor, that is true.
And the language in many revisions tracks it identically.
Looking to the legislative history of the Clean Air Act, the House report noted that air encompasses a broader geographic range than does water. But also, the plurality in Rapinos did also note that adjacent was ambiguous in the abstract.
Well, are there any cases that help you out and support the theory that functional interrelatedness is the same as adjacent?
Your Honor, in the McLaren's versus U.S. EPA case, the court did hold that oil wells spread over an expansive area in a hub-and-spoke model were adjacent. But our position is more supported by common sense than anything else.
Well, you mentioned you went through a number of dictionary definitions of adjacent and then argue that those definitions don't foreclose the use of functional interrelatedness. Can you point to me any dictionary definition of adjacent that defines it as functionally interrelated?
Well, Your Honor, not necessarily using the exact term functional interrelatedness, but as Franklin pointed out, adjacent is a relative term. And what EPA thinks of functional interrelatedness as is a way to clarify the context of physical proximity. So I think that a good analogy would be a public transit system. The Washington, D.C. Metro, for example. Cities that are connected to the city of Washington, D.C. through the Metro are more likely to be considered adjacent than cities that are not. It elucidates the context of the physical proximity. Similarly here...
That's not a good example for you, because there are parts of the Metro that go way far out, but they're in close-in communities that don't have Metro access. Is that really the analogy you want to use?
Well, Your Honor, it's a good analogy because physical proximity...
So you're saying that Wheaton is closer in proximity than parts of Prince George's County that are directly touching the border because Wheaton's got a Metro line and PG County doesn't?
Actually, that example perfectly exemplifies EPA's position, which is that physical proximity is actually a very important consideration, along with functional interrelatedness. We consider both physical proximity and functional interrelatedness to both be very important characteristics. It's not just based on the functional interrelatedness. But, Your Honors, also it's clear that adjacent is a context-dependent term. For instance, the Earth and Mars are adjacent planets, but they're separated by much more than 6 miles or 50 square miles. But if I'm holding a ball here, that's not adjacent to a ball in Mars. So as Franklin pointed out, adjacent is a relative term or an ambiguous term. That's especially true here, where the functional interrelatedness of all of the facilities actually have a physical point. Nothing outside of the process, either physically or functionally, interrupts the flow of gas from an underground field through the gas wells to the flares and then to the gas sweetening plant. That's a quote directly from the dissent in the Sixth Circuit case of Summit Petroleum Corporation, which Franklin heavily relies upon. And, Your Honors, the Sixth Circuit case had a strong dissent, which agreed with the EPA. And after the Sixth Circuit case of Summit Petroleum, EPA pointed out that in all areas other than the Sixth Circuit, that it wanted to uphold its longstanding interpretation.
Did EPA seek certiorari from the Sixth Circuit decision in Summit?
No, Your Honor. It did not.
Well, if it was such a strong dissent, why didn't they seek Supreme Court review?
Instead of seeking Supreme Court review, it's not upholding the rationale of the Summit majority in any area other than the Sixth Circuit.
You're telling us that the EPA is willfully violating an order of the U.S. Court of Appeals?
Oh, no, not at all. In the areas encompassed by the Sixth Circuit, EPA is upholding the Summit decision, which is the only areas.
So you have inconsistent positions across the country, depending on what circuit you're in?
Not by our choice, Your Honor. EPA's longstanding interpretation of adjacency is defined by its functional interrelatedness as well as physical proximity. And that's actually an interpretation that EPA has held constant for the last 30 years.
Except if you're in the Sixth Circuit, then it's inconsistent.
Because of the Summit case, which with EPA disagrees.
Okay, so if the EPA is inconsistent in its decision-making, why should it be accorded any different deference by this Court?
Your Honor, EPA is not inconsistent in its decision-making. Looking to this particular case here, EPA, pursuant to the State Farm Motor Vehicles Manufacturers case, needs to be able to assert a rational connection between the facts and the choice made.
Let me ask you a question about that. It's the same question I asked your colleague. I don't understand, why does this functional relatedness test have anything to do with dispersal of airborne pollutants? Maybe you could help me out with that one.
Yeah, Your Honor, it's because ambient air has a broad geographic range. Dispersing pollutants into the ambient air isn't only limited to physical proximity. No matter where they're dispersed, they're
Wouldn't it make a heck of a lot more sense to do like we do in the nuclear industry all the time, to have a scientist figure out how far the particulates are dispersed depending on what's put in the air at any given point, and do a scientific analysis based on particulate dispersal? Wouldn't that make a lot more sense than just this sort of proxy of functional relatedness?
No, Your Honor, and it would be out of line with the regulatory history of this particular regulation. The preamble to the 1980 regulations focuses on a common sense notion of a plant. And here, EPA is defining adjacent by a common sense notion of a plant. And when it comes to a plant that has multiple parts that are connected through a giant underground network of pipelines that certainly abides by the common sense notion of a plant.
Now, the appellant, I believe, argued, and articulated it probably better than I will, that even assuming functional interrelatedness should be a part of the definition, that in fact these facilities are not functionally interrelated. What do you say to that?
EPA would disagree with that contention, and EPA's disagreement is based on the 30 years of applicability determinations. In each applicability determination, EPA has defined functional relatedness as, for instance, plants connected through subsurface pipelines or plants that work together in a shared function. Here, we have wells providing a product, making the product go through a subsurface pipeline into a natural gas sweetening plant. This is clearly in line with EPA's longstanding definition of functional interrelatedness.
Now, am I wrong? I may have misread this. There's flaring from each of the wells themselves, right? So you have dispersal into the atmosphere from each of the wells as well as from the sweetening plant.
Yes,
right?
Your Honor, that is true.
Okay. So, but you're not talking about one source of dispersal into the air. You're talking about multiple sources of dispersal, understanding that source has a different connotation in this case.
Yes, Your Honor, that is true. And to talk more about that point, the natural gas sweetening plant emits less than 100 tons per year, but aggregating it with any one of the wells would be sufficient for a Title V permit.
Do you have any particular distance that you would require before you would allow this functional relatedness to come into effect to hold you in under the rule of adjacent?
EPA does not, and EPA has never been able to set such a distance, and the reason for that.
What's some examples of ones that you've ruled upon, or you have any idea?
Well, in some applicability determinations, especially one example, 2 smokestacks that were a mile away did not meet the common sense notion of adjacency. And the reason for that was that they didn't have any functional interrelatedness, and it wasn't in line with the common sense notion of adjacency.
So 1 mile in that case didn't do it. What's the farthest distance between the wells here? It's more than 1 mile, isn't it?
Yes, Your Honor, it is 6 miles here.
Are there any wells within 1 mile of the sweetening plant?
Yes, Your Honor. There is one well that's 1,000 feet away, which is about 1/3 of a mile away.
So wouldn't it be more rational to vacate the decision below and remand and tell the agency, look, maybe the sweetening plant and that one well within a mile might be a single source, but the rest of them aren't?
No, Your Honor, because EPA considers the entire plant to encompass the common sense notion of a plant. Furthermore, this Court cannot provide a post hoc rationale for an EPA's decision. EPA is really concerned with the common sense notion of a plant, and in this case, in the natural gas industry, which is a newly emerging industry, adjacent really does mean 6 miles away. In this case, EPA's decision was not arbitrary or capricious.
Let's say one of them was 30 miles away. You would still be arguing, wouldn't you, under the functional relatedness test, that it would be fine?
I can't speak to that case in particular. It would really depend on the degree of functional interrelatedness. I think it would be likely that in that case, however, that the physical proximity would be too much for it to meet the common sense notion of adjacent in that case.
So 6 miles is close enough, but 30 miles isn't?
Probably not, but I can't say because I don't know the exact specifics of that case. Your Honors, for the foregoing reasons, this Court should not vacate EPA's decision to aggregate Franklin's production plan and various natural gas wells as a single and therefore major source under Title V of the Clean Air Act. If there are no further questions, thank you, Your Honors.
Thank you.
Thank you, Chief Judge. Chief Judge, judges, may it please the Court, my name is Andrew Missel, and I represent the United States of America, the appellee. We respectfully ask this Court today to affirm the conviction of Franklin Gas Company entered by the District Court for the Northern District of Vandalia for violating the Migratory Bird Treaty Act, 16 U.S. Code, Section 703. There are 3 reasons this Court should affirm the conviction. First, The misdemeanor provision of the Migratory Bird Treaty Act prohibits more than just direct takings of birds. It prohibits indirect takings of birds as well. This is clear from the plain language of the statute, its purpose, and subsequent congressional action. Second, the application of liability in this case does not violate Franklin's due process rights because the statute is not vague and because, as the district court found, Franklin proximately caused the deaths of 5 birds. First, this statute applies to more than hunting, poaching, and the like. Multiple courts have agreed with this proposition. For instance, the 10th Circuit, United States versus Apollo Energies, found that an oil operator who had birds found dead in its heater treaters could be liable under the Migratory Bird Treaty Act.
Under this same statute?
Yes, Your Honor.
And that would come under by any means, in any manner?
Yes, Your Honor.
That would not be a hunter, a poacher?
No, Your Honor. Precisely. The by any means, at any time, in any manner broadens the scope of liability. The verbs in 16 U.S. Code Section 703, take, hunt, pursue, capture, and kill, are broadened in their meaning by the language appearing in front of them at any time.
What is the meaning of take?
A take is defined in the regulations as to kill, wound, pursue, or capture.
And all of those require a volitional act.
Your Honor, the dictionary definition of kill from 2 separate dictionaries of the early 20th century, the first edition of the Oxford English Dictionary and Merriam-Webster's Dictionary, around the time of the passage of the Migratory Bird Treaty Act, define kill as to deprive of life by any means or in any manner. Kill has a meaning much broader than just intentional killings, which is why criminal law textbooks typically feature a subchapter on intentional killings to qualify, to make it clear that not all killings are intentional.
So is it your contention that if 2 10-year-olds are playing baseball in a field and one of them hits a baseball up into the tree and kills the migratory bird, you can prosecute the 10-year-old, juvenile issues aside, for taking the bird because he killed it?
Your Honor, no, because under the proximate cause standards set by 10th Circuit in the United States versus Apollo Energies, the 10-year-olds would have to be on notice that their activities could cause bird deaths.
Let's say there was a sign near the park that says, migratory birds inhabiting, be careful, don't kill the birds.
Our position, Your Honor, is that that would be a technical violation of the statute. In fact, the Fish and Wildlife Service notes that building collisions are technical violations of the statute. These are all technical violations of the statute.
Does that make any sense? Make sense of that for us, please.
Well, 16 U.S. Code Section 701 sets out the purpose of the Migratory Bird Treaty Act, which is the object and purpose of this act is to aid in the restoration of such birds in those parts of the United States adapted thereto where the same have become scarce or extinct. It was Congress's intent to ensure that bird populations were not depleted. In other words, they were interested in the effect of depleted bird populations, not in prescribing any particular kind of conduct.
Is there any requirement in the treaty that the U.S. certify that it or its states have complied with certain provisions to protect the birds? For example, in a number of treaties involving food products, plant products, the U.S. has to certify that it is complying with those provisions. And in those situations, the courts have occasionally adopted strict liability requirements, but is there any certification in this statute?
Your Honor, I'm not aware of any certification requirement. It is worth noting that Canada, which was the original treaty partner of the United States in the Migratory Bird Treaty Act, does impose liability for indirect takings of birds. Although this is only persuasive, it is worth noting.
Have they applied that to a situation here where you're talking about fracking and water induction?
Your Honor, I'm not sure if they have. I do know that, like the Fish and Wildlife Service, the Canadian agency charged with administering their version of the Migratory Bird Treaty Act pursues a common-sense enforcement policy, just as the Fish and Wildlife Service did in this case.
Well, let me ask you this question. What more could Franklin have done here?
Your Honor, as the record notes at page 6, the Fish and Wildlife Service asked Franklin to render their ponds harmless to birds. What Franklin could have done was render their ponds harmless to birds. Because it's a strict liability statute.
How?
Your Honor, they could have, for instance, installed the netting higher above the water line. The record at page 7 notes that Franklin installed the netting on many of its ponds in such a way that a minimal increase in water volume would lead to the ponds overflowing.
But EPA inspected that netting, right? And it never said your netting is too low. It never said we want you to jack the netting up 6 feet, did they?
Your Honor, the Fish and Wildlife Service did inspect the netting quarterly, so at most twice. The record doesn't reflect exactly how many times they inspected the netting, but they did inspect it at least twice between January and August of 2011. However, there was no regulatory requirement to put up the netting. The Fish and Wildlife Service...
So they went above and beyond here in putting up the protective netting. Why should Franklin stand in the same shoes of other companies who just do nothing at all?
Your Honor, because it is a strict liability statute, just as product manufacturers take great care to avoid creating defective products, they're still held strictly liable in tort. This is also applicable in a criminal context in so-called public welfare offenses, which it is our position this statute is.
Okay. Since your position is strict liability, doesn't the rule of lenity apply even more strongly here? And since you haven't articulated, or the Fish and Wildlife Service hasn't articulated in a clear, comprehensive fashion exactly what protections are necessary, shouldn't they be entitled to acquittal because you haven't, under the rule of lenity, made things clear enough?
Your Honor, the Supreme Court has made it clear that the rule of lenity is only a last-ditch effort. If after grabbing all the tools of statutory interpretation, a criminal statute is still ambiguous, the rule of lenity is to be applied. However, in this case, we have a statute whose language is crystal clear. As the Tenth Circuit noted in Apollo Energy's, no birds can be taken. That is the clear meaning of the statute. That is, from reading 16 U.S. Code Section 703, it shall be unlawful at any times, by any means, or in any manner.
Does the EPA know what killed the birds?
No, Your Honor. No toxicology tests were done on the birds to determine what killed them.
Then how is there a taking by Franklin?
Your Honor, the district court found, as a matter of fact, that Franklin was the cause, in fact, of the bird deaths. It based this on a number of facts. First, an affidavit filed by Officer Ranger of the Fish and Wildlife Service, who noted that these impoundment ponds are invariably filled with harmful chemicals.
He also noted he did not know what the chemicals were in this pond, correct?
No, that's correct, Your Honor. He did not. However, just a year before this event, some 200 birds were found dead in Franklin's ponds and in ponds in the area of other gas companies.
There weren't 200 dead birds in only Franklin's ponds, were there?
No, Your Honor. It was
How many?
In Franklin's ponds, initially, it does not specify how many birds. At the time of the taking that this case is about, there were 14 birds found dead near Franklin's impoundment pond, 5 of which were protected by the market.
So that only gets you so far as something in that area or where the birds had been are killing the birds. It doesn't get you to the point of Franklin's impoundment ponds killed the birds.
Your Honor, 2 points. First, the 3 of the birds were found dead in the pond. They were in the liquid, however, on top of the netting. Some of the unprotected birds, some of the 9 birds that were killed but which were not covered by the Migratory Bird Treaty Act, were found underneath the netting in the liquid. The other 2 protected birds were found outside the netting.
How did they get underneath the netting? Do we know that?
No, Your Honor. The record does not reflect that.
So isn't it possible that there was some other source of water not on Franklin's territory that was pushing these birds along and that they may have died somewhere else and then been pushed by the water onto Franklin's property?
Your Honor, that is certainly a possibility. However, the district court found, as a matter of fact, that Franklin had caused, in both in fact and in the proximate cause sense, the deaths of the 5 birds. Their findings of these facts are subject to reversal only on a finding of clear error by this court.
What about just the term common sense? That's where they found them.
I'm sorry, Your Honor?
What about the term common sense as to why they pointed the finger to Franklin? It's where they found them. That's where they...
Precisely.
Unless somebody put them there.
Precisely, Your Honor. The district court concluded, based on the totality of the circumstances, the birds being found in the impoundment ponds invariably being filled with some combination of volatile organic compounds, toxic heavy metals, and sometimes even radioactive materials, that the birds had died as a result of being exposed to the chemicals in the impoundment ponds.
I'm sorry. Would your case be stronger if the charging document had charged them not only with taking but also killing?
No, Your Honor, because the term take in the Migratory Bird Treaty Act is defined in the implementing regulations to include the word kill. So we don't believe that there would be any difference if Franklin had been charged with killing instead of or in addition to taking.
So I just want to sum this up for you. You're saying that even though Franklin had no proven intent to harm any bird, even though the birds could have come from a neighboring piece of property, even though we don't know how the birds died or got onto the property, and even though we have a rule of lenity that says you have to clearly state what the rule is that you're violating, notwithstanding all of this, Franklin is liable for a strict liability criminal offense. That's your position.
Your Honor, as to the first point, yes, because we believe that the statute prescribes more than just direct takings of birds. As to the second and third points, yes, because we believe the district court correctly concluded that Franklin proximately caused the deaths of birds. And as to the fourth point about the rule of lenity, yes, because we do not believe the statute is ambiguous at all. Furthermore, recent congressional action bolsters this interpretation. In 2002, the District Court for the District of Columbia heard the case Center for Biological Diversity versus Peary. The court in that case concluded that the military, the Navy in particular, was in violation of the Migratory Bird Treaty Act due to its bombing operations that incidentally resulted in bird takings. In response to this, Congress passed the Incidental Military Take Amendment in 2003, explicitly exempting the military for liability under the Migratory Bird Treaty Act for incidental takes. This suggests that Congress intended for incidental takes to be covered under the Migratory Bird Treaty Act, and that it felt it had to exempt the military for public policy reasons. The application of the Migratory Bird Treaty Act to Franklin in this case does not violate due process. Colander versus Lawson sets out stands for the proposition that a criminal statute must define the offense in such a way so that a person of ordinary intelligence knows what conduct is prescribed. The Migratory Bird Treaty Act sets out with crystal clarity what results are prohibited: dead birds. As the Tenth Circuit noted in Apollo Energies, when combined with a requirement of proximate causation, that is, that the result of dead birds be the foreseeable result of an action, the Migratory Bird Treaty Act does not violate due process. Moreover, there is no problem here with notice. Appellants contended that the notice must be present in the statute. However, in Apollo Energies, this was not what the court found. The the Tenth Circuit in that case relieved one party of liability because they had not been subject to the public information campaign done by the Fish and Wildlife Service, which was very similar to the campaign in this case. But they affirmed the conviction of Apollo Energies, who had been subject to the campaign.
Isn't it true that there are several cases out there that disagree that the word take applies to anything other than intentional killings?
Yes, Your Honor.
And doesn't that by itself defeat your argument? If, in fact, there are a number of cases saying only intentional killings are covered by the statute, doesn't that make the statute ambiguous enough that under the rule of lenity or just plain principles of interpretation, you can't hold a party to a strict liability criminal standard?
No, Your Honor. A split among courts, among circuits or district courts does not by itself render interpreting a statutory term differently does not by itself render the term ambiguous. In this case, there are two circuits, the Eighth and Ninth Circuits, who, comparing the language of the implementing regulations of the Migratory Bird Treaty Act and the Endangered Species Act, have held that takings do not include indirect deaths due to habitat modification. While we do not agree with those results, insofar as those cases concern habitat modification, if we consider the direct-indirect dichotomy rather as a spectrum, habitat modifications would be on the far indirect end of the spectrum, whereas...
Isn't there a real danger under your theory that the EPA could target certain industries over others?
Your Honor, yes, but as the Supreme Court noted in United States v. Dodderwijk, our criminal justice system depends on prosecutorial discretion, depends on the conscientious behavior of prosecutors. Outside of an equal protection claim, which appellants do not bring today, it is not for courts to review the choices made by prosecutors. If in the future the Franklin or similar gas companies want to bring an equal protection claim alleging invidious discrimination, they can do so. That is not an issue in this case.
Are they right, though, that the timber and logging industries generally are not prosecuted for incidental takings of birds?
Your Honor, I can't say as an empirical matter whether that's true, but it is true that in the Eighth and Ninth Circuits, they likely would be exempted because those circuits have said that habitat...
And those are the circuits where at least a great deal of logging and timber operations occur?
Yes, Your Honor. That's true.
I guess I don't understand why completely unintentional water induction is more directed at birds than habitat modification.
Your Honor, our main point is that this distinction between direct and indirect makes no sense, and that all activities that proximately cause bird deaths should be covered. However, to the extent that we give deference to the Eighth and Ninth Circuits for their decisions, we do believe that birds alighting upon a poison-filled pond is different from birds losing their nesting spaces, for instance. Thank you.
All right, you have 2 minutes.
Your Honors, I have 2 points on rebuttal. As Judge Johnson asked the appellant in this case, the respondent in this case, how the sources are functionally interrelated, the respondent replied that they are functionally interrelated due to pipelines. However, holding such a precedent would say that any company transporting their goods through a pipeline, through the railway system, or even roads could be considered adjacent through this result. And as Judge Thacker pointed out, the EPA has been inconsistent in applying these results and thus has acted arbitrarily and capriciously. Regarding the Migratory Bird Treaty Act, Your Honors, Judge Rosenberg indicated that this statute could produce absurd results, such as children playing baseball and being held liable for a bird dying that gets hit by a ball. Later on, the appellee cited Colander v. Lawson, saying that this statute is clear in applying criminal liability. However, it is not clear, as the appellee failed to indicate that nothing else that Franklin could have done to render these birds harmless, and that Franklin in fact followed everything suggested by the Fish and Wildlife. And
he did say they could have put the nets higher. Is that something that realistically you could have done?
Yes, Your Honor, they could have put the nets higher, possibly, but as this was an unforeseeable event, there would be no reason for Franklin to know that the floods would raise above the level of the netting.
How could it be an unforeseeable event if this has happened in other places with other similar operations?
Your Honor, it was unforeseeable because as storms were not typical at this time of year, and as storms are typical in May, and no storms occurred in May that rendered these ponds harmless to the birds, Franklin could not foresee that any harm would occur, and therefore this Court should vacate the final aggregation determination of the EPA.
To be clear, you're saying Franklin was not aware of any prior floods that went over the level of the netting you put up? Is that what you're saying?
Yes, Your Honor. As the record indicates, Franklin's operations were the same throughout this entire period. And I see I've run out of time. May I answer Judge Rosenberg's question and briefly conclude, Judge Thacker?
You may.
The record indicates that Franklin's operations were the same throughout this entire period. And during May, that when the floods would have been likely to occur, Franklin's floods did not rise to a level that rendered the birds harmless, and therefore Franklin would not have noticed that such floods would occur at this time. Thank you, Your Honors.
Thank you.